Good afternoon and welcome to our Foreign and Comparative Law webinar, Two Sides of the Same Coin, the Evolution of Surrogacy Law in France and Colombia. I'm Louis Gilbert, the French Foreign Law Specialist at the Law Library of Congress, and with me is Stefania Alvarez, the Foreign Law Specialist for South and Central American Jurisdictions at the Law Library of Congress. So if you have any questions, we ask that you submit them through the question and answer feature. Just click on the question and answer button at the bottom of your Zoom, input your question and hit send, and we'll respond to them. Now, welcome again for those of you just joining us, the Foreign and Comparative Law webinar. Today we're going to be discussing the evolution of surrogacy in Colombia and France, and how these two jurisdictions, although opposites, may complement each other to allow foreign nationals, such as EU citizens, to access surrogacy contracts. So, I'm going to start by talking about the variability of international legal frameworks. It's important to note that surrogacy is permitted in several countries. Countries that allow surrogacy include Georgia, Colombia, and the US. Additionally, altruistic surrogacy, which is not through a contract and not remunerated, is allowed in Argentina, Australia, Canada, Greece, Guatemala, Mexico, and the UK. Within these jurisdictions, surrogacy is sometimes strictly regulated, as in Canada or the UK, and sometimes more liberally, as in some US states, Ukraine, or Georgia. A quick note, this is not an exhaustive list, and it serves as an illustration of the variability between different countries. Now, the discordance between French law and that of other countries highlights a contrasting international landscape. This diversity leads to a trend where although some surrogacies have a purely national context, it's often the case that the prohibition imposed in one country leads families to cross a border so that they can fulfill their desire for a child by traveling to a country that makes the procedure possible. This global legal disparity creates complex situations for French people who have recourse to surrogacy abroad. So once back in France, these parents encounter difficulties in having their parent-child relationship with the child recognized, particularly when neither of them has a biological link to the child. The question then arises of how to legally allow the child's return, which involves understanding and comparing legislation. Beyond the legal entry of a child born as surrogacy into a given country, jurists are also faced with the question of the standard of child protection in general. Often, to compensate for the lack of legislation, it is the courts that have found themselves obliged to adopt a position. Now, a quick note, although this presentation focuses on surrogacy in France and Colombia, the war in Ukraine provides a striking illustration of the legal tensions associated with this transnational practice. Ukraine is one of the few countries that permits commercial surrogacy for foreign nationals. Since the outbreak of the conflict in 2022, many French intended parents have faced unprecedented legal challenges, including births without civil status certificates, inaccessible Ukrainian courts, difficulties repatriating children, and even the need to arrange unregistered births in France. This crisis has exposed the lack of force majeure clauses in Ukrainian surrogacy contracts and the limits of their enforceability under French law, which, as we'll see in an instant, considers such agreements void on public policy grounds. It also raises complex questions about nationality for children born via surrogacy in conflict zones. In contrast, the situation underscores the distinct characteristics of French and Colombian legal frameworks, which regulate surrogacy in very different principles. The crisis reveals the ethical and legal fragilities of transnational surrogacy in the context of conflict and calls into question the ability of states to protect the rights of children, women, and families in these extreme situations. So, our presentation is going to follow the order of typical fact patterns for surrogacies carried out abroad. We're first going to look at the legal situation in Colombia before coming back and studying how these surrogacy agreements are then recognized in France. Right. Now, Stefania is going to tell you about surrogacy in Colombia.
Good afternoon. As my colleague mentioned, I'm Stephanie Alvarez, and I'm very pleased to speak with you today about Colombia's legal framework on surrogacy a subject marked by significant constitutional and jurisprudential developments in the absence of direct statutory regulation within the country. So to begin, it is important to note that surrogacy in Colombia exists within a legal gray area. There is currently no specific legislation regulating surrogacy arrangements. However, it is not expressly prohibited either. Instead, there's legal recognition derived primarily from constitutional provisions and jurisprudence, particularly rulings issued by Colombia's constitutional court. In this case, the leading precedent is Judgment T 968 of 2009, which provides a foundational interpretation of surrogacy and legal parameters that govern it under Colombia's constitutional framework. In that decision, the court defined surrogacy as a reproductive act resulting in the birth of a child carried by a woman subject to an agreement or commitment whereby she must relinquish all her rights over the newborn in favor of another woman who will be recognized as the mother. In this scenario, the surrogate woman does not provide her own eggs. As you can see, this definition establishes several key legal elements within them, that there are typically three parties: the intended father, the intended mother, and the surrogate. The surrogate must relinquish all parental rights following birth. The child's legal mother is someone other than the gestational carrier, and also that the surrogate does not contribute genetic material. In this case, her own eggs are not used. And the parental rights vest in the genetic contributors are those who provided the egg and the sperm, which we will examine these requirements in more detail later in this presentation. Wonderful. Okay, as we previously mentioned, although Colombia lacks specific legislation on surrogacy, it has constitutionally recognized its permissibility. Specifically, two constitutional provisions are particularly relevant that provide the foundation for assisted reproduction and children's rights. In this case, Article 42 of the Colombian Constitution acknowledges the legitimacy of children conceived through scientific assistance, affirming that children born in or out of wedlock, adopted, or conceived naturally or with scientific assistance have equal rights and duties. Therefore, as you can see, this article guarantees the equal right protection status for all children, regardless of the method of conception, implicitly supporting assisted reproductive techniques, including surrogacy. Legal scholars and the Constitutional Court have interpreted this article as implicitly allowing surrogacy under certain conditions, even in the absence of direct regulation. Additionally, we have Article 44 of the Colombian Constitution, which establishes children's fundamental rights, such as the rights of family, care, and protection, and gives these rights precedence over others, which creates a framework that values family, diversity, and child-centered legal decisions. Wonderful. So we're going to talk a little bit more about the primary source of regulation for surrogacy in Colombia, which is in this case jurisprudence, particularly from the Constitutional Court. In this case, the most influential decision, as we've mentioned before, is Judgment T 968 of 2009, which originated from a contentious surrogacy arrangement involving a Colombian national called Mr. Salomon and a surrogate named Sarai, also a Colombian national. Mr. Salomon and his wife Raquel sought to become parents. Mr. Salomon entered into an arrangement with the surrogate Sarai, who initially agreed to undergo a fertility treatment using Raquel's eggs. After multiple failed attempts, Sari agreed to use her own eggs, resulting in the birth of twins. After birth, the intended father stopped supporting Sari and sought to take custody of the children, which eventually the Colombian Institute for Family Welfare removed custody from Sari and assigned it provisionally to the children's paternal aunt. Multiple legal actions followed, with Solomon seeking to strip Sari of any legal standing. Additionally, the children were later registered as extramarital with no known father, prompting to further legal conflict. So this case is a complex judicial process followed in this case, involving multiple contradictory rulings by the 10th Family Court of Cali and interventions by the Superior Court and then the Supreme Court of Justice. In this case, although the Superior Court of Cali ruled in Sari's favor in 2008 and its decision was upheld in 2009, none of the rulings have actually been effectively enforced. So despite judicial rulings that were in Sari's favor, the children were removed from her care and taken abroad by the intended father. In this particular case or judgment, the Constitutional Court noted that children's fundamental rights to, for example, as to a family, love, and care, remained violated despite extensive judicial involvement, prompting a renewed constitutional review of the best interest of the child and the legitimacy of the custody proceedings. The court's review in this judgment emphasized on the primacy of the child's best interest, especially when parental agreements clash with the welfare and stability of the child. In the case at hand, there were some key considerations that we should take into account, or the judge took into account to consider the best interest of the child. One of them was guaranteeing the comprehensive development of the child, ensuring the full exercise of their fundamental rights, and also balancing the rights of the child and those of the parents, which the child's rights are more important than the rights of the parents in this case. Furthermore, the court considered that the mother, although had fewer rights than the father because she initially agreed to carry a child for Salomon and Raquel using Mrs. Dominguez's eggs in exchange for compensation to improve her family's living condition. This does not automatically disqualify her from asserting her children's rights. Nor does it disqualify the father who knowingly enabled and funded the entire process that led to the twins' birth through assisted reproduction, and who had no issue at the time with choosing a young, healthy, but of course economically vulnerable woman to be the surrogate, yet now denies her role as a mother because of her social and economic status, which she was fully aware from the start. And as you can see, well, this case reveals the vulnerabilities of surrogates and the need for a more robust legal framework in Colombia. So the Constitutional Court has consistently stated that in all actions taken by private individuals or public officials involving minors, the principle of best interest of the child must guide all decisions, including surrogacy-related decisions. The court has established constitutional, legal, and jurisprudential rules for determining the best interest of each child, depending on the specific circumstances, which these include guaranteeing the comprehensive development of the child, also ensuring conditions for the full exercise of the child's fundamental rights, protecting the child from prohibited risks, in addition to balancing the rights of the children and those of their parents based on the primacy of the child's rights. Also providing a suitable family environment for the child's development and requiring strong justifications for state intervention in parent-child relationships. In case of conflict, also, the rights of the child and those of the parents, as mentioned before, the child's rights will always prevail in this case. The Constitutional Court has also highlighted the need for comprehensive regulation and for compliance with several conditions, including first, that the intended mother must have physiological problems preventing conception. Two, the gametes used must not come from the surrogate. There must be no genetic contribution from this person. Three, the surrogate must not be motivated by profit, but by the desire to help others. So there's an altruistic tendency. Four, the surrogate must meet criteria such as being of legal age, physically and mentally healthy, and also having had children. Another requirement is that there is mandatory medical and physiological evaluations, which must be conducted before, during, and after pregnancy. This means that the surrogate must undergo required medical and psychological evaluations throughout the whole pregnancy and even before. Another additional requirement is that the identities of the parties must be preserved. Also, once the informed consent is signed by the parties, and the reproductive material is implanted in the surrogate cannot back out of this agreement. Also, a requirement that has established the Constitutional Court in Colombia is that the biological parents cannot reject the child under any circumstance. This means that the intended parents must accept full parental responsibility after, of course, the informed consent is signed and the reproductive material implanted. An additional requirement is that the biological is, for example, or in case the biological parents die before birth, is that the child must not be left unprotected in this case, or in surrogacy related cases, and also that the surrogate may only terminate the pregnancy for medical reasons. And these are overall the requirements that the Constitutional Court has established for surrogacy in Colombia up to today's date. Okay, so the legal enforceability of surrogacy contracts in Colombia remains contested. Legal academics suggest the general theory of transactions, in this case contracts, applies to surrogacy from a family transactional perspective. However, there's other academics that believe that surrogacy contracts shall be null and void, specifically due to the potential conflicts with human dignity, commodification of the body, and non-transferable nature of parental rights. To date, Colombia has not issued guidance or specific rules on remuneration and cost. And when I mean Colombia, I mean like the Constitutional Court of this country. In Colombia, legal parenthood in surrogacy arrangements is determined using two primary legal principles. First, we have biological genetic parentage. This means the genetic connection, which is confirmed by DNA, establishes a biological parentage. Under Colombian law, specifically civil law, biological parentage is typically confirmed through DNA testing, which serves as a conclusive presumption of paternity or maternity. And also in relation to certain applicable provisions, in this case, of the Children and Adolescents Code. Secondly, there's the intent-based parentage, which is derived from the doctrine of intentionality, which holds that legal parentage may be attributed to those who intended to become parents, provided there is evidence of informed consent, a surrogacy agreement, and participation in the reproductive process of the intended parents. This is especially relevant in gestational surrogacy, where the surrogate's only role is to carry the pregnancy and both gametes are donated by the intended parents. In this cases, the usual presumption that the woman who gives birth is the mother can be overridden by legal and scientific evidence. Also to note is that in the absence of direct regulation, courts have discretion to evaluate parentage on a case-by-case basis, often, as we mentioned before, balancing the best interest of the child, which is constitutionally written in Article 44. Also, certain public policy principles, which include non-commercialization of the human body and evidence of the parties' conduct, intentions, and formal agreements that they've had. And just to take into account, judicial intervention is usually required to resolve disputes regarding maternity, especially when the gestational mother and intended mother are not the same person. Courts have recognized that the presumption of maternity based on childbirth is rebutable, with clear genetic and contractual evidence, therefore needing the genetic link, but also the intent-based link, which is required to transfer the paternity or maternity in Colombia's surrogacy legal framework. In summary, surrogacy in Colombia is currently constitutionally recognized, but not legally regulated by a specific law. As we saw before, Judgment T-968 of 2009 remains the cornerstone of jurisprudence, emphasizing the best interest of the child and highlighting the gaps in legal protection for surrogates and intended parents. Current legal tensions present in Colombia's surrogacy framework are the lack of specific legislation, which creates legal uncertainty. Surrogates are often in vulnerable economic positions, which of course may lack protection once they relinquish the child. There's also tension between biology and caregiving, especially when intended parents reject responsibility post-birth. And in this cases, judges must carefully balance legal arrangements, ethical considerations, and real-life impact on children and the surrogates. Also, courts in surrogacy cases must weigh the surrogate's informed consent versus the coercion or need. Also, the genetic ties with the emotional and physical labor of gestation, and the rights of the intended parents with the surrogate's post-birth rights. And also there's an urgent need for comprehensive legislation that protects all parties involved. There's also a need for legislation that can clarify parentage and custody standards and that upholds the best interests of the child.
All right. Thank you, Stefania. So as we just saw the legal requirements for surrogacy in Colombia, we're now going to compare and contrast with the situation in French law. So since the 1990s, France has taken a clear stance on surrogacy. It's strictly prohibited. The main legal basis is Article 16-7 of the French Civil Code, which states that any agreement concerning procreation or gestation for the benefit of another person is null and void. This nullity is absolute, so this means that the agreement is deemed to never have existed. This prohibition is based on the principles of the dignity of the human person, the unavailability of the human body, and the non-patrimonialité, I don't think this is a word in English, of personal status. What this means, in other words, is that you cannot rent a uterus or contractualize the birth of a child, nor can family ties be created or modified by contract. The aim here is to protect the dignity of the woman and child, avoiding any commodification of body or filiation. So here we already see a clear distinction with Colombian law, where, as Stefania pointed out, the theory of contracts applies. Now, understanding this prohibition in France, its justification, and its contrast with foreign legislation is essential to understanding why French and European case law has evolved so much in recent years. So now I'm going to take us on a journey through the evolution of the jurisprudence in French law. So before 2014, the French Supreme Court, otherwise known as La Cour de Cassation, has long opposed any recognition of surrogacy carried out abroad, even if legally established. The main reason for this was to prevent fraud against French law and protect fundamental principles. So let's remember the big F word, fraud, is the main concern of the French courts before 2014. Case law before 2014 considered any surrogacy agreement to be null and void, and this means that even if the child was born abroad within a legal framework, French courts refused to recognize the legal effects of the birth. The only prevailing logic was that of protecting public order, to the detriment of any consideration of the child's interest or parentage. In a landmark ruling handed down on December 13th, 1991, the Cour de Cassation overturned an adoption decision when the birth was the result of a surrogate motherhood contract. It stated that the agreement by which a woman undertakes, even gratuitously, to conceive, bear, and abandon a child contravenes public policy. So on December, we're going to start talking about the Menesson case, which is a landmark piece, just a landmark decision in this area in France. On December 17th, 2008, the Cour de Cassation refused to register the American birth certificates of the Menesson twins born in California to a surrogate mother. The court considered that such a transcription would indirectly validate a surrogacy agreement, which is prohibited in France, and would therefore be contrary to French international public policy. So the practical consequences of this is that this rigid rejection for the children born through surrogacy abroad had the following effects. Firstly, they had no filiation recognized under French law. Secondly, they could find themselves with no effective nationality, no inheritance rights, and no social security coverage via their intended parents. And lastly, the intended parents had no parental authority and could have the child taken away from them in the event of a family dispute or separation. In other words, French law protected the prohibition of surrogacy at the cost of the children's legal security. And this is where the interest of the child, this concept comes into play, and we're going to look into that a little bit more later. The Menesson case was then brought before the ECHR, which we'll get into in just a moment. So in 2013, there was a start to a shift as France was debating the opening of marriage to same-sex couples. The debate was accompanied by strong tensions over filiation and new forms of parenthood, particularly in the case of surrogacy carried out abroad. It was against this backdrop that the then Minister of the Interior, Manuel Valls, took a stand on an important administrative issue, the issue of French nationality certificates, which were given to children born through surrogacy abroad. So through a circular from January 25th, 2013, the circular addressed the issuance of these French nationality certificates to children born abroad to French parents, when there's a strong likelihood that surrogacy or similar arrangements were involved. So it had specified that the mere existence of such an arrangement is not in itself grounds for denying a nationality certificate. So this step represented an important, although limited, evolution in the French position on surrogacy. It did not legalize surrogacy. Also, it did not allow foreign birth certificates to be transcribed into French civil status. And lastly, it did not recognize the parent-child relationship with the non-biological intended parent. What it did do is merely recognize a right to nationality based on biological parentage with a French parent. This circular provoked strong reactions, particularly from members of parliament who were opposed to surrogacy. Some saw it as a legal ploy to indirectly recognize children born from surrogacy. But to its defenders, it met a requirement of minimum legal security for children, in line with Article 18 of the French Civil Code, which grants French nationality to any child who has at least one French parent. Further, in two rulings dated September 13th, 2013, the First Civil Chamber of the French Supreme Court reaffirmed its refusal to transcribe into French civil status the birth certificates of children born under a surrogacy agreement abroad. The court reaffirmed that the notion of the child's best interest does not, in this case, justify regularizing fraud against French law. So once again, we have this the opposition between the best interest of the child and fraud. Nor does the formal regularity and veracity of the birth certificate. The court also relied on the concept of fraud against the law to justify annulling the act of paternal recognition, citing Article 336 of the French Civil Code, which allows the public prosecutor to challenge legally established filiation in cases of fraud. The court held that demonstrating fraud alone was sufficient. It did not require proof that the recognition contradicted biological reality. So this leads up to the 2014 ECHR judgment. As you remember, I talked about the Minnesota case 2 slides ago, and this is where it ended up. So the European Court of Human Rights ruled that refusing any recognition of paternal filiation violated the child's right to privacy. So just restating the facts, 2 French couples who had used surrogacy in the United States were denied registration of their children's birth certificates by the French authorities. They brought their case before the European Court of Human Rights, ECHR, arguing that this refusal violated their right to respect for private and family life under Article 8 of the European Convention on Human Rights. So in a ruling of June 26, 2014, the ECHR found that the refusal did not breach the couple's rights to family life, given the wide margin of appreciation states enjoy on surrogacy, and the fact that the families were able to live a life comparable to other families. However, the court did hold that France's refusal to recognize the children's legal relationship with their intended parents, especially their biological father, violated the children's right to identity and private life, contrary to their best interests. Following this judgment, France was required to adopt its legal approach. The French Supreme Court, Cour de Cassation, then set itself to align with the position that the mere existence of a surrogacy arrangement abroad no longer prevents the transcription of a foreign birth certificate, provided it is lawfully issued and reflects established facts. So here we can see the argument of the best interest of the child, which we also saw in Colombian law. It reappears here and prevails over the defense of the public order and fraud. This leads us to a change of position by France's Supreme Court. Now, although surrogacy remains strictly prohibited in France, the ECHR rulings have compelled French authorities and courts to take into account the best interest of the child, particularly regarding the recognition of parent-child relationships established abroad. These rulings have progressively shaped French jurisprudence, notably through decisions by the Paris Court and the Cour de Cassation. In August 2016, the French Supreme Administrative Court, the Conseil d'État, also required the Ministry of Foreign Affairs to authorize the entry into France of a child born in Armenia through a surrogacy agreement. Another development came on September 18, 2018, when the Cour de Cassation authorized the full adoption of a child by the husband of the biological father of 2 girls born through surrogacy in Canada. This marked an important step towards recognizing intentional parenthood within same-sex couples. Under the continuing influence of ECHR jurisprudence, the French Supreme Court has since accepted the transcription of foreign birth certificates, provided certain legal conditions are met. In 2019, it extended this position to two same-sex male couples, ruling that transcription could not be refused solely because a child was born through surrogacy, or because the foreign birth certificate listed the biological father and another man as parents. As long as the foreign document is lawful, free of fraud, and compliant with the law of the issuing country, it must be transcribed in France. In 2018, the Cour de Cassation referred a question to the ECHR, which then issued an advisory opinion on April 10, 2019. The court stated that a blanket refusal to recognize the legal relationship between a child born via surrogacy abroad and the intended mother was not compatible with the child's best interest. Although the ECHR did not require automatic transcription of foreign birth certificates, it insisted that a legal path to recognition, such as adoption, must exist. Now, in line with this opinion, the Nantes Regional Court recognized on May 23, 2019, the parentage of an intended mother for a child born via surrogacy abroad. However, on November 19, 2019, the ECHR clarified that France's refusal to transcribe the intended mother's filiation did not violate the convention if adoption remained a viable and legally accessible alternative. The court considered this an adequate and proportionate solution for recognizing the parent-child bond. Finally, in a ruling dated July 16, 2020, the ECHR reaffirmed that France's refusal to register the intended mother as the legal mother on a foreign birth certificate does not breach the right to privacy, as long as the adoption procedure remains available to establish legal recognition of the relationship. So on August 2nd, 2021, France passed the bioethics law, which clarified that the recognition of parentage established abroad must be assessed in light of French law. As a result, the transcription of a foreign birth certificate for a child born through surrogacy was limited to only the biological parent. The intended parent had to follow an adoption procedure to establish a legal bond. This legislative framework remains more restrictive than the jurisprudence of the courts. The 2021 law therefore tightened the legal framework, limiting direct recognition to only biological parents. The legislature has thus chose to strictly frame the effects of a surrogacy performed abroad. Finally, we have some very recent decisions that kind of shifted the landscape for us here. The most recent decisions show a desire to protect the child's right while maintaining a restrictive approach to surrogacy. The Cour de Cassation, the Supreme Court, even accepts the recognition of filiation without a biological link, provided that certain guarantees are respected. So in these cases, on October 2nd, 2024, the Court of Cassation issued two significant rulings concerning the recognition, or exéquatur, in France of foreign judgments establishing the parentage of children born through surrogacy abroad. In both cases, French male couples had obtained court decisions in Canada and California, recognizing them as legal fathers, and sought recognition of those judgments in France. The court clarified that a foreign judgment establishing parentage may be recognized in France if it, first, was issued by a competent court, two, was not obtained through fraud, and third, complies with French international public policy. In addition, the foreign judgment must clearly identify all parties, confirm the surrogate mother's informed consent and waiver of parental rights, and take into account both the child's best interest and the privacy of all parties involved. When these conditions are met, foreign parentage judgment must be recognized in France with the effects provided by the foreign law, even if the process used abroad was not formal adoption. These rulings mark a significant step towards the recognition of parentage for families formed through surrogacy abroad. I'll also point out that the informed consent of the surrogate mother closely resembles the conditions that we just saw in Colombian law. Finally, in a decision handed down on November 14th, 2024, the French Cour de Cassation, the Supreme Court, confirmed that parentage legally established abroad for a child born through surrogacy could be recognized in France, even in the absence of a biological link between the child and the intended parent. The court held that the lack of a biological connection does not violate any fundamental principle of French law. As with all surrogacy cases, however, the judge must verify that there was no fraud and that all parties to the surrogacy agreement gave valid consent. Now, this brings us to our conclusion. Although French law prohibits surrogacy, France is required under pressure from the ECHR and in light of fundamental right considerations to recognize the parent-child relationships legally established abroad, including in countries such as Colombia. Colombia's legal framework governing surrogacy, including the issuance of birth certificates and naming the intended parent, provides the necessary documentation for French nationals to seek recognition of these filiations in France. The complementarity of these two systems stems from the Colombian jurisprudence, where the surrogate mother relinquishes her rights. And on the other side of the Atlantic, the French system, which requires this relinquishing and creation of a new filial link, with the intended parent. All right. And that concludes our presentation. I'm now going to look to see if we have any questions. I think I saw a few come through that I was interested in answering. The very first one I see here is, what is the difference between altruistic surrogacy and commercial surrogacy? Well, this is a great question. So in altruistic surrogacy, the surrogate is not paid for carrying the baby beyond reimbursement for reasonable expenses. And in commercial surrogacy, there is usually financial compensation beyond just these expenses. It's considered a transaction, and as Stefania related about Colombian law, contract law is involved usually in this. Let me see if there are other questions. So there's a question regarding the best interest of the child here. Actually, this is a really interesting question as well. And I'm really happy to address this. The question reads, regarding the best interest of the child, do the courts regularly check in with families to ensure the best interest of the child are being met? Or is this only consideration during the surrogacy process, like before the child is born? So this, I can answer on the French side, and I might hand it over to Stefania to see if she has anything to add. But on the French side, this is usually when it's usually considered by the court when a party is trying to have the filial link between them and the child born by surrogacy recognized by the French court. And jurisprudence has shown that the French court are going to consider things like the stability of the family environment, whether or not there were any emotional bonds, and most importantly, the child's legal identity and rights. What the ECHR really pointed out was it's clearly against the best interest of a child to cut them off from all filial links and then have a child with no nationality. And it's also contrary to law to have somebody born of a French parent who is not then French. So those are all the things that are considered. So the risk of statelessness, I would say, is also a really big factor. And these are considered usually in French courts, at least. And then I'll let you tap in, Stefania. But in French courts, it's usually right as they're trying to have the judgments, the foreign judgments or the foreign birth certificates recognized in France. Did you have anything to add?
Yes, thank you, Louis. Well, in the Colombian case, I would like to say that the court is only at this stage if there's a conflict. Therefore, there's only judicial intervention to resolve disputes regarding maternity, paternity, or any surrogacy related case. And courts will take into account when understanding the best interest of the child, what is the development of the child in each family sphere with the parent, with the father, the intended father, with the uh, intended mother, and also like, well, in as we saw in this judgment, it was a complex case because it wasn't just um, the eggs that were used weren't from the intended mother, but from the surrogate itself. Therefore, the court had to analyze, okay, what would be the development of these children here in this place, and then in the other family place with the surrogate, which in this case was the mother of the twins. But they also take into account like what are the child's fundamental rights, the rights to have family, the rights to visit their mother, to visit their father, to be cared for them. And they balance these rights with the mother. I think in the question they're asking about if this could be done before the child being born, um, that would only arise. I believe that can be something that the court can handle or can take or can um, provide a judgment for. They would have to still analyze all these specific circumstances of the child and their best interests, which the Colombian Constitutional Court has certain rules about what to understand from a child's best interest and what should be considered when taking when making a decision of who the child should spend their time with, or who will have custody of the child, or who or when establishing paternity and which rights of the custody of the child will be met. But that's also on a base like a case by case basis, which they will analyze all of these circumstances. Yeah.
Oh, I see another one that's not a question, but somebody added a clarification that there are contracts involved in altruistic surrogacy as well. And I just wanted to chime in and to agree with that. Yes, um, there are also contracts involved in altruistic surrogacy to clearly define the roles and responsibilities of the surrogates and intended parents. Um, there, it's more of a question here of remuneration for the commercial, and also the enforceability of these contracts is going to vary depending on your jurisdiction. But uh, thank you. All right.
Um, I think there is someone asking if they will have access to the presentation with all the legislation. Um, I believe an email will be sent with the presentation afterwards to the participants.
Yeah, and I'll just chime in here. They will have links as well, so the slides.
Wonderful. And we also have another question, which is, are there other countries similar to Colombia which are attractive destinations for reproductive tourism, either due to the same factor as Colombia, where it is recognized by the country's constitution but not regulated by law, or by other factors? And I would like to say yes, there are other destinations that are known for their reproductive tourism and easier to have surrogacy agreements due to their deregulation or other factors. But if you have like a particular question about a certain or specific country that you would like to touch base about, you can always use Ask a Librarian to answer those questions. We would
I can
be
also
very happy. Yeah. Sorry, Louis.
absolutely. No, that's a great point. Ask a librarian is great if you want specific answers. To give you a more broad answer as well, just by looking at the jurisprudence in French courts, we really see that a lot of similar countries come up when parties are trying to have their birth certificates recognized in France. So the top countries are usually Georgia. I'm thinking Ukraine until recently, which is why I mentioned it at the beginning of the presentation, and also the United States. Pops up in a lot of fact patterns. A lot of California cases where somebody, had a surrogacy agreement and then tries to come back to France. Now, of course, I'm staying hyper specific just because our presentation just covers France and Colombia, but these are definitely things that we see pop up in the jurisprudence. All right, so I don't see any other questions. Just gonna
Well,
give it. All right, well,
yeah.
I hope I hope you all enjoyed this presentation, and feel free to reach out to us. As we've said previously, there'll be links sent out to the presentation itself so you can access the resources.
And I would like to just add something to this, Louis, and it's that you're very welcome to join the next Foreign and Comparative Law webinar, which is on July 17th, 2020 of this year, of course. And it's about how to handle AI, the Italian national regulation in context of European law. It would be great if you could attend, and it's very insightful, and we definitely want to thank you for attending this webinar.
All right.
Great. Thanks so much, everyone. Have a great day.